Welcome to the program. My name is Marty Schenkman, and I'm joined by Alan Gassman, a colleague and a brilliant attorney. And the topic for today is going to be talking about asset protection planning for physicians and their practices. We hope to make this a very practical program that will help not only physicians but their advisors. If you're a physician and not an attorney or professional advisor, the program is really presented for educational purposes only, and you really absolutely must speak to your attorney and other advisors to implement any of the planning. Please keep in mind that the laws vary state by state, and you want to make sure that whatever it is that you do to protect your assets works in your circumstances and under your state law. Before we begin, it's my custom on every webinar that I host to promote a different charity, and today I'm honored to have a charity that is very meaningful to me personally, the American Cancer Society, say a quick word. Jamie?
Yep. Thanks so much, Marty, for the opportunity to be on the call today and for all you do to support the American Cancer Society. Quickly want to share with you all that our mission is simply to save lives, celebrate lives, and lead the fight for a world without cancer. We're working to deliver on this mission by attacking cancer from every angle through advocacy, research, prevention and early detection efforts, and patient service programs. I encourage you to review the slide that we've included here and also visit our website, which is just www.cancer.org, to learn more about the important work that we're doing in local communities all across the United States. So thank you again, Marty, and I hope it's a great call today. Thanks.
Thank you. Wonderful organization, certainly deserving of all our support. Did anyone from Peak Trust make it on yet?
Hi, Marty. Yes, this is Nicole King.
Hi. So let me introduce Peak Trust. Peak Trust is one of our sponsors. Peak is a trust company in Alaska, and by way of full disclosure, I personally have a self-settled domestic asset protection trust for my own family with Peak Trust, and I also have a spousal lifetime access trust for my own family with Peak Trust in Alaska, with Peak as my own trustee. So I don't think I could give you a better endorsement than that. So why don't you say a few words with that introduction?
Well, thank you. We're pleased and honored to be able to sponsor today's presentation. Just to kind of extend on what Marty said, I'd like to take this opportunity to tell you a little bit about our company. We serve individuals, families, and their advisor teams by offering a full range of customized fiduciary solutions with a choice of preferential jurisdictions. Our mission is to facilitate, protect, and preserve our clients' wealth, vision, and legacy by taking a client-centric approach. While Peak is a full-service provider, our services are unbundled, and our core business is working with other advisors to help achieve a client's goal. If you should have any questions, please don't hesitate to contact myself or any member of the Peak team. Our contact information can be found on the materials for this program, and you can browse our website at www.peaktrust.com. And with this, I'll turn it over to Marty. Thank you.
Thank you. Let me just make a quick comment before I turn it over to Alan, who's going to lead the charge, and I'll comment as we go. Couple of comments. One, I not only introduced Peak by saying what I have, but I think it's important to say that a lot of the planning that we're going to talk about, where appropriate, I've personally done. I think it's important that advisors, if they really believe in what they do, take steps to protect their own families. And for those of you who are not advisors, I think that's important to understand, because you want to make sure that the planning you're doing is really practical and not just something being sold to you. One of the biggest mistakes that I see, and one of the biggest problems I see with quote-unquote asset protection planning, there are firms and companies out there that are selling products, that are selling packaged canned stuff, and I have seen nothing positive come from a number of those programs. What I believe you really want, and I'm not saying in general to dismiss any of those, but you have to be a careful consumer. And if you're a professional advisor, you have to be careful on what you're advising. Every asset protection plan needs to be tailored to the specific individual. Every document needs to be tailored to the specific individual and their circumstances, goals, and objectives. and be very leery of anything that's prepackaged, because it just not everyone's alike, and it just is worrisome whether things like that can work. So just keep that caution in mind. And as we go through the program today, and by the way, this is a two-part program, and you should separately register for the second part. The slide deck you have now, which is about 140 slides, will be used part for this program, and what we don't cover in this program, we'll try to cover as much as we can in the next program. And also keep in mind, we've given you a lot of information in the slide deck, and Alan, it's his deck and his creation. So a lot of the materials we won't cover in detail, but they're still there for you as a resource. Alan, why don't you lead it off and say any introductions you'd like to say?
Beautiful, Marty. Well, thank you very much for having me, and it's a great pleasure to share the stage with great organizations like the American Cancer Society and Peak Trust and Interactive Legal. I've been doing work for physicians for 37 years now, and it was the focus of my practice in the first 20 years. And there's a lot of different things to think about. The checklist should be pages long when you think about and execute how to protect your physician clients. So as Marty said, we have a lot more material than we can cover, but I wanted you to have it because it's readable. So some of these slides I'm going to cover in detail. Some of these slides I'm just going to tell you what's on them. But at page 6, I want you to know that it's very important to have a good relationship with your physician client and the spouse of your physician client, if applicable, because while they're very brilliant and they have a lot of education, it will be surprising as to what they don't know, and also a bit unpredictable. So for example, on page 6, when I speak to groups of physicians, I ask them, how many of you can raise your hand and tell me how much you have to save between now and retirement age in order to retire comfortably? How many of you in this room know that? And I would say less than 20% of them know that. So it's really important to make sure that we have a holistic approach when you represent a physician. Second here, how much life insurance do they need, and what kind of life insurance should they buy? Physicians, quite candidly, get taken advantage of a lot of times, and they end up in expensive products that they don't need. So if you are an estate planning lawyer or a CPA or a financial advisor for physicians, let's be very careful to protect them with all of the different protections that they need. Marty, let's go to page 7.
Alan,
Yes.
let me just add a couple points, because I think there's so many important points on slide 6. Let me just jump in real quick. Alan's comment about life insurance is not an anti-insurance comment. Insurance can be an incredibly important component of your plan, but you do need to understand what you're buying. You do need a reputable, knowledgeable, intelligent insurance consultant that understands what your needs are, and the planning with the insurance should be tailored to coordinate with all of the other planning. And let me just emphasize that the key point that I see on slide 6 is one of the most important points to plan for a physician client. You need a collaborative team. You want an independent accountant, an independent attorney, an independent insurance consultant that work together. That is one of the most important steps to make sure the work is done right. The best attorney can't do the job perfectly, and maybe not even really well, if it's not coordinated with a good accountant and a good wealth advisor and a good insurance consultant.
Absolutely. So some of the things that I tell the physicians when I speak with them is not to spend too much money on a house. I find a lot of physicians have big houses and small savings accounts. So I tell them, if you need 6,000 square feet to be happy, go see a psychologist, not a realtor. The next thing I tell them that you see here is numbers don't lie, but people who use them do lie. And almost every successful physician will be ripped off at some stage of his or her career. So you want to be very careful, and that goes to the next point, using a team of advisors independent of each other. A lot of physicians will meet a financial advisor or an accountant who will say, don't worry, I'll take care of everything. And my best friend is a lawyer and you won't even have to meet her. I'll take care of that too. And then there's no independence. I'm sure Marty and I can both tell you many stories where we were the lawyer, there was a CPA, there was a financial advisor, and one of the three of us started to slip or made a mistake or suddenly did not have good intent. And the other two advisors can spot that and get it handled. So, and we do encourage clients to use financial advisors who are independent of an accountant so that the accountant is watching the financial advisor and the financial advisor is watching the accountant. And by the way, Peak Trust Company has a fantastic platform for investments. They typically are not involved with the investments, but if you have questions, you have a client who has an investment portfolio and you're not really sure whether that portfolio is suitable for the client, Peak Trust Company has the ability to look at that for you and let you know if it makes sense for the clients. Let's go to the next page. So I also talked to the physicians a little bit about personal success. They typically don't have a to-do list. They typically don't have written goals. They typically have not learned how to be organized, to be quite candid. So you could talk to them about that and help them prioritize things, and they can be much more effective both as people and as clients. Let's go to the next slide. So we also obviously are going to want to use estate planning, trust planning, and wills, powers of attorney, and that types of things. So talk to the clients about what their family objectives are. Make sure that we protect their family objectives. Let's go to the next slide. There's a book that I wrote with a very successful physician and a very successful business coach. It's called Grow Your Medical Practice. If you email me, I will be glad to mail you or email you a free copy of the book. We're quite proud of it. It's really helped a lot of physicians. And chapter 9 covers asset protection, so that would give you more resources than you see even here. Next. Concentrate on the process and make sure that the physician knows that there's a process. Don't require them to give you all their information and all the documents before the first meeting, or you will never have a first meeting. And you may never receive all of their documents. But it's important to get what you can get. In the first meeting, you want to talk about checks and balances, the use of qualified advisors, helping them size up their other advisors and recommending what advisors they should be using. And then you explain to them the customization of their planning and explain to them what other advisors you need to bring in. We are a 6-lawyer firm in Clearwater, Florida. We bring subspecialist lawyers in to help us just about every single day, whether it's securities law, malpractice law, liability law, certain estate tax rules. Physicians are fine with that. A lot of your clients would think that you're not so smart if you have to bring in someone to help you, but physicians will be very understanding if you need to bring in another specialist.
And I think that's in part because that's how physicians themselves operate, by referring in specialists for different issues. So they are comfortable with that. Let me just make a comment. It may be out of place, but I think it's very important. It is difficult to get all the documents. It's overwhelming for clients, physician clients especially, to do it because how busy their schedules are. One of the things that I tend to do is rely on the team, as Alan spoke about, the accountant, the insurance consultant, the wealth advisor. And after the first meeting, I will circulate a draft memo before it goes to the physician client to the other advisors on the team. And assuredly, each advisor will have some pieces of information that we didn't glean or weren't provided at our meeting. Each advisor may have documents or other information that we didn't have. And when I get that information back and update the memo before it goes to the client, it keeps all the advisors on the same team. It saves extra work and time for the physician client and gives a better result.
Very good. I agree. Let's go to the next slide.
You want to go to 13?
Yes. I emphasize to the clients that they need to use a good certified public accountant. I explain what a certified public accountant is, and I suggest that they find a certified public accountant who will sit down with them, make some eye contact, have a cup of coffee, and talk about what's important. When Marty and I first started practicing law back with the covered wagon days, most accountants and lawyers had a friendship with their clients and acted like an uncle or a cousin or a close friend, listened to what's going on, and then made suggestions. These types of advisors and these relationships are now fewer and farther in between, but I do recommend that everyone on this call try to be that good advisor, try to be that caring advisor, try to understand what emotional support, what business support that physician needs and their family, and give it to them. But also let them know that the CPA is usually a very good gatekeeper as far as knowing if and when they'll need services from lawyers and other third parties, and what they should be doing from a financial planning and investment standpoint.
Just let me emphasize Alan's point. I worked for decades as a CPA before going into law. CPAs, by their nature, by their training, are skeptical. If a physician client is going to purchase an investment, it is a great idea to run it past the CPA. If a physician and client is going to undertake a plan, if the CPA has a concern or a question, it may not be the ultimate answer, but it's always worth getting that independent input. So great idea, Alan.
Okay, so page 15, my subspecialty that I'm probably most recognized for in Florida is creditor protection. So a lot of physicians come to me when things are not going so well, and it's usually not malpractice liability. So most of the people on this call are thinking, oh my gosh, I need to make sure I cover malpractice liability and there's no other problems. But there's a lot of exposure and a lot of other problems and reasons that beyond just putting everything in the physician's spouse's name, you have to look at everything they're doing and everything they own and look for the generation of liability exposure. And we've just given you, part of a list here. They could be joint and severally liable with somebody because they're partners and they don't have an LLC agreement. They co-sign notes, they guarantee promissory notes with business people who then disappear and the doctor has to pay the bank back a loan. I mean, they end up being accused of being co-conspirators because they get into friendships with bad people who then rat on them. I've had at least 7 physician clients in my career arrested in their lobby by the FBI for being accused of paying off blood labs and other entities when they had nothing to do with that. So physicians need to watch who they have relationships with, and you need to talk to them about that. We recently had a physician who went to a football game with someone that he referred to. It was an expensive ticket, but what was more expensive was about $100,000 of legal fees to defend that physician to keep her medical license. So we do need to just go through these things with them. Some of them have medical practices and very loose financial controls, and the office manager doesn't pay the payroll taxes. And then $100,000 later, the IRS walks in and says, why haven't you paid your payroll tax? The office manager disappears. The doctor owes money. So the list goes on. And as a good advisor, it's your responsibility to go over this list, make sure that the clients understand some of these exposures. Let's go ahead and see what the next page is. We also need to explain to physicians that there is just about nothing we can do to prevent them from having to pay alimony, property settlements, and child support. I get all kinds of phone calls. Well, oh, can I set up an offshore asset protection trust or a Nevada trust to avoid having to pay alimony and property settlement and child support? And I say, yeah, you can. And then you'll get free room and board in jail when the judge puts you there on contempt. So we want people, to be careful. On the topic here of sexual discrimination and also potential situations where doctors are accused of making inappropriate advances to employees or people they work with, it's a good idea to have an anti-harassment policy signed by all employees where they know that they can call an anonymous third party and report anything like that and give them an affirmative obligation to report something like that. So 3 to 4 years later, a thwarted relationship does not become the bankruptcy of a doctor. And I think everyone on this call knows the potential liability for real estate. I prefer that the real estate be in an LLC or another company. I prefer that the doctor not be the manager of that company. I prefer that the company be leveraged with a bank or by private indebtedness with the doctor. I prefer that you don't have 10 buildings in one LLC where one lawsuit could cause the loss of 10 buildings. I don't think I have to say much more about that. So let's go to the next slide.
Let me just add a quick comment on that. One of the most common problems I've seen amongst wealthy clients, not just physicians, but wealthy clients in general, is they often try to be very gracious and to share their success with family members. And I've seen physician clients own a home or apartment or condo that one of their kids is living in, or a condo a parent is living in. And oftentimes the insurance is structured completely incorrectly. It may be that this family member is living rent-free and it's treated for insurance purposes as a primary residence for the physician themselves, which may negate the coverage. I've had physicians own condos that their kids are living in for free, wild parties, and all the things you can imagine. So sometimes it's not just commercial real estate, but something that seems very innocuous that could turn out to be the Achilles heel of the asset protection plan.
Absolutely. So one huge liability exposure, and probably the one that brings more physicians down than anything, is who drives their car. You have a situation where one spouse has taken a child to get their learner's permit and has signed the state documents to be responsible for the child's negligence. Then the child goes and drives the other spouse's car and gets in a terrible accident, and all of their assets are exposed. So it's really important to talk about who owns the physician's car and what the liability insurance is for it. I typically want the physician to own her own car. I'm not crazy about having the car under the medical practice entity, because then you're exposing accounts receivable, furniture, and equipment if there's an accident. If the accountant wants to have the car under the practice entity, have the practice entity set up an LLC, have the LLC own the car, so that you would hopefully have firewall protection for the medical practice or whatever other business may own the car. And don't take the doctor's word for it as to the ownership of the car. If you are able to, pull a LexisNexis report or pull a report from the state. They'll tell you that they each own their own car, but usually they're wrong. People don't know who is titled to their car. Let's see what's next. Now, one objective that I have as an estate planner in this area is to know that whatever bad things might happen to my client will not cause loss of all their assets, and that the client would hopefully be able to file a Chapter 7 bankruptcy, be done with a judgment, and be able to keep the majority of the assets in the family. But there's some liabilities that are really thorny and difficult. On the left-hand side here, things like student loans, IRS withholding monies, certain hazardous waste liabilities, any breach of a fiduciary duty, child support, alimony, and paying back Medicare and penalties. cannot be bankrupted out. So when a client comes to you with a lot of problems, you want to handle these 6 problems first. Sometimes when clients have problems, you know they have multiple problems. You want to make sure that this client with these issues on the left-hand side, if they're acting as the fiduciary of a trust, make sure they're doing it right. If they own real estate, they're buying real estate, make sure they do their phase 1 and phase 2 reports and they put the real estate in an LLC and someone else is the manager. If the marriage isn't going to work out, try to get them out of that marriage without unpaid child support, unpaid alimony. So all of these are issues that come up. And then the doctors typically say, well, I have insurance, don't I? I've got a big umbrella liability policy. Well, on the right-hand side, you see things that we typically run into where the liability insurance policy doesn't cover it. If you want to have fun with a client, ask them to bring you the liability insurance policy and point out that 2/3 of the pages are the exceptions for what the policy does not cover. So we want to be careful there. Let's go to the next page. There are also super creditors that can reach assets that would otherwise be exempt creditors. This is the IRS, this is the Department of Justice when they're looking for restitution. And by the way, a lot of physicians have a very unjust result when they are practicing medicine responsibly, they're doing the right thing for the right patients, but they haven't done the paperwork right. For example, you might have a client with 4 radiology centers and an office manager, and 3 of them got the paperwork done right, and 1 of them did not properly register with Medicare as an independent testing facility. Medicare gets hold, an employee files a whistleblower action. Medicare shows up and says, okay, you did $4 million in volume before you properly registered this facility. We don't care that all $4 million was for people who needed it, properly prescribed, and that you did the right job. You weren't registered, so you owe us $4 million, and you owe the whistleblower $1 million. Thank you very much. And you can't bankrupt it out. So this stuff does happen. There are certain things you can do which will protect against a future unexpected super creditor. One of those things is a properly drafted and funded asset protection trust. You have a client who doesn't expect to ever have a problem. They put part of their nest egg in an irrevocable asset protection trust. They put the rest in their homestead, which is protected 100% under Florida, Michigan, or Texas law. Then it turns out they open a radiology center. They owe Medicare $4 million. Medicare can't reach that trust. It was set up not for the purpose of avoiding them. But the house is gone. So just keep in mind that this stuff does happen.
Let me interject a comment. One of the problems I see uniformly with physicians and others seeking to do asset protection planning, take the point Alan just made. If you set up a proper, irrevocable, say, domestic asset protection trust or some variation of that in advance, when there are no claims, no issues, and time goes by, long time before anything else arises, there's perhaps a meaningful likelihood that those assets will be safe. But the problem becomes is so many physicians, when they first start out, are still earning smaller amounts. They're still saving. They may be paying back debt. And the attitude becomes, well, you know what? I'm going to wait until I have more money, and then I'll go to the lawyer and set up that trust. It would be much wiser to set up the trust early in their career, long before any claims or issues arise. And then so long as there are no pending issues, make additional contributions or gifts rather to that trust over the years, rather than wait until you have whatever enough money means to warrant doing the planning. So don't defer the planning. Get the planning, guide the physician client to do the planning early on and add to it. Don't defer it, because then it may be too late.
Agreed. Okay, let's go to the next slide. All right, let's go over some definitions here. This is to help with some literacy and some information. A fraudulent transfer on page 21, this is not fraud, and in most states, it is not illegal. It is a transfer made for the primary benefit, for the primary purpose of avoiding a creditor. Clients do have issues, they do have lawsuits against them, and if you can estimate what they need to set aside for the lawsuit to cover it, or reasonably conclude that their insurance will handle the situation, then in most cases, or in many cases, it will be ill-advised to have them sit with that asset in their name. In other words, a physician comes to me and says, I'm being sued, I have $1 million of malpractice insurance, my lawyer tells me it'll probably settle. Even if it doesn't settle, it'll probably not exceed $1 million. And I have $500,000 in my name, and a lawyer at a cocktail party told me I can't move it to my wife because if I do, that would be fraudulent and it would break the law. This situation needs to be very carefully handled by a lawyer or lawyers who are very well versed in this area. Most of these lawyers are known as bankruptcy lawyers because bankruptcy lawyers have the best background in debtor-creditor law. Communications should be very, very carefully handled because the attorney-client privilege and confidentiality in the lawyer's file may not apply if the lawyer is helping a client make a transfer that may thwart a creditor. In some states, like California and Connecticut, it's clearly illegal for a lawyer to help a client avoid a creditor. In other jurisdictions, most notably Florida, we actually have a duty to help a client avoid a creditor. And the Florida Supreme Court has said that making a transfer to avoid a creditor is not illegal, is not unethical. It's what people do to try to put their families in front of banks that may have, loaned them too much money. So I say all that just to try to help to facilitate a mindset. If you make a transfer and a court later decides that it was made for the purpose of avoiding the creditor, in most states, the only remedy is that the asset has to come back into the creditor's hands, plus attorney's fees and costs. So don't be flippant, don't be naive, and don't try to practice debtor-creditor law unless you are a debtor-creditor lawyer. The best thing you may do is bring a debtor-creditor lawyer into a meeting to let the debtor-creditor lawyer guide the situation. Do you have any comment on that, Marty?
One of the things that you should also think about is trying to document before you make a transfer that it should not be a problem. So, and I don't know if you're coming to this later, but I'll just mention at this juncture. So having a physician client that's going to make transfers to an irrevocable trust, for example, have them sign a solvency affidavit, even if it's not required by state law where the trust is structured. Have a balance sheet prepared and signed by the physician client. Even better, have the physician client CPA prepare a personal financial statement that corroborates the status. We have an independent forensic firm do an evaluation of many of the clients before transfers are made so that they can independently document that there are no known claims, liabilities, or issues to the extent they can find it before transfer is made. So there are things you can do to also improve the position before making any transfer.
And think about the ethics of this. If you don't want to get yourself in trouble, and as our friend Howard Zaritsky says, just because the client's problem should not become your problem, the best thing you can probably do for that client is refer them to someone who's willing to take the risk for them, as long as what's going to happen is legal. So, and quite candidly, a lot of people move to Florida for that reason, because in Florida, as I said, it's not a crime, but if they reside in a northern state, it can be a crime. Now, a preferential transfer at the top of page 22 is would include a transfer from a company that is expected to be insolvent. So when you have a physician client's practice being sued, and it is an S corporation, and you're paying out dividends, the creditor may be able to get those assets back, and you may want to raise the salary and have less in dividends. Charging order is something we're going to mention later, but if I own a company and Marty gets a judgment against me, he can take the company. But if I own 95% of an LLC and a trust for my children owns 5% of the LLC, and Marty gets a judgment against me, in many jurisdictions, the only thing Marty can get is called a charging order, where the judge orders me and the LLC, pay Marty, but only if and when we make a distribution. So there's a deadlock. I can't take anything out, and Marty can't get anything out, and usually creditors will settle when a charging order is their sole. Then I talk about bankruptcy here at the bottom of page 22.
Alan, let me interject a quick comment. One of the silly situations that I see very commonly with charging order protection is many physician clients will own assets such as rental real estate, side business interests, whatever, in a wholly owned single member LLC. And the reason they're doing it is because they don't want to incur the incremental cost of having their CPA file a partnership tax return each year. It's really a very much, to use the old adage, a penny wise, pound foolish concept. So make sure that you go over with the physician client the value of what Alan just talked about, because the insignificant, in my view, cost of paying an accountant to do an extra tax return is nothing compared to the additional protection that could be obtained.
And also, in my example, I own 95% of the LLC. A trust for my daughter owns 5%. I have the power to exchange trust assets for assets of equal value in the trust for my daughter. Then that trust can be disregarded for income tax purposes. The LLC can be disregarded, and all the income goes on my tax return. You should have the accountant involved to make sure that you dot the I's and cross the T's. You treat it as an actual 5%, 95% ownership, so that a judge doesn't look at it skeptically. Now, there's two other things I want to mention about charging order protection. One is the client may live in a jurisdiction that doesn't have charging order protection. What we almost always do is, not only do we give part ownership to that gifting trust, but we split the ownership into 1% voting, 99% non-voting. So we give the trustee of the irrevocable trust 0.5% voting, 4.5% non-voting. I keep 0.5% voting, 94.5% non-voting. Now, even if charging order protection doesn't apply, when they get hold of ownership, they can't take over the control of the company, and I'm still the president or the manager of the company. Another thing I want to mention is that last year we had an Iowa Supreme Court case, which is the first case I'm aware of, which found that Iowa law applied to allow charging order protection for a debtor who resided in Florida and who had asked for Florida law to apply. So if you live in a state that doesn't offer charging order protection, like California, and you want to try to have charging order protection, you might set up the LLC in a state that has charging order protection, like Wyoming or Delaware or Florida. And then, according to this Iowa Supreme Court case, you may still have charging order protection. So, Marty, I'm ready for the next
One second.
Okay. Secured interest. If a mortgage on property gives the creditor the right to the first dollars out of that property, and somebody taking over that property, a creditor taking over that property, would have to pay the mortgage in order to take over control of the asset. You need to look at your medical practice assets and find a way to give a mortgage those assets to what I will call a friendly creditor. For example, a lot of times clients come to me and they have a billion-dollar building with a $900,000 mortgage and no debt against the medical practice entity. So why not have the medical practice entity become a guarantor on the real estate mortgage and pledge its assets as additional collateral on the real estate mortgage, so that it is less likely that the mortgage holder would ever pursue the doctor's guarantee. Now, when the practice gets sued, the first money from the liquidation of the medical practice is going to go to the bank. It's going to reduce the mortgage on the real estate, and the malpractice claimant is not going to get anything. Another yes.
Alan, I think in your example, you would have the building owned perhaps by an irrevocable trust, so it's out of the reach of the creditors.
Yes, exactly.
Yeah.
Yes. Okay.
That,
Now,
by the way, is a very clever concept that too often is overlooked, where you look at the practice, the buildings, the other assets, and the physician's personal planning all holistically in order to do the planning that Alan just said. It's not just the simple planning of taking the non-practice building assets and protecting those. It's really looking at everything together.
right. Now, and all of these concepts are going to be further discussed in the later slides today and in part 2. Bad faith is a law which says that if an insurance carrier doesn't do a good job defending a doctor and there's a verdict in excess of policy limits, then the insurance carrier has to pay what we call the excess verdict. A game is played, and you need to understand this game well enough to refer the client or to help the game be played. The plaintiff lawyer would like to get a check. Plaintiff lawyers typically don't like to go to trial. Some of them do, but most of them don't. They just want a check. So let's say the doctor has liability insurance of $250,000, and a possible jury verdict would be $500,000 to $1 million. The plaintiff lawyer offers to settle for $250,000. The doctor says, that's ridiculous. I did nothing wrong. There's no way I'm settling. Let's go to trial. Or the lawyer who is working for the doctor but getting paid by the insurance company says, no, I don't think we should accept that offer. I can win this case. And by the way, I don't get paid if I settle. I get paid a lot if I go to trial. Well, the right advice to this doctor most of the time is to have an independent lawyer write a letter to the insurance carrier which says, dear insurance carrier, I represent Dr. Jones. I recognize that Dr. Jones did nothing wrong, but a jury might conclude that he did. The plaintiff lawyer in this case has a lot of experience, and you could end up with an excess verdict. So we politely demand that you settle this matter at the $250,000, or we will consider you to be responsible for any excess verdict. Now, the law in this area varies from state to state. For example, Florida has a very strong bad faith law. It's in the story I just told you, there's a 98% chance that the insurance carrier is going to be responsible for any excess verdict if they don't settle. New York has a much weaker bad faith law, but it does have a bad faith law. When you have a physician client telling you about the lawsuit, please tell them about the bad faith rules and usually when they call their lawyer, who's paid for by the insurance carrier, and say, should I have a separate lawyer write a bad faith letter? That lawyer that's representing them will typically say, yeah, I'm glad you thought of it. I think you should. So now page 25, or the next page rather. It wasn't raining when Noah built the ark. There are different types of fraudulent transfer statutes. This is from the Uniform Fraudulent Transfer Act. It's complicated stuff, but certain transfers will not count against you 4 years or 6 years after the transfer is made, even if it was made to avoid a creditor. And other types of transfers can be undone 100 years later because the creditor has the longer of the 4 or 6 years, or 1 year from when the creditor knew or should have known about the transfer. I'm just pointing this out because a lot of people on this call are lawyers and you're advising clients, and I just want to make sure that you recognize the difference between certain types of transfers and certain other types of transfers when strategy comes up, because a lot of people don't think about this stuff. What's next, Marty? Also, please talk to the client about their umbrella liability insurance. Almost always a busy, wealthy physician with a vacation home, a car at the vacation home, a couple of boats, so a travel trailer, you're going to find huge gaps in the coverage. Most of the wealthy physicians should have a $5 million umbrella. It's not that much more expensive than a $1 million umbrella. It makes no sense at all to say that your umbrella should be equal to your net worth. It has nothing to do with your net worth. The umbrella is if you need coverage for when bad things. The same thing, Marty, for our elderly clients. Elderly clients tend to back their Mercury Marquis into people in the parking lot. Get sued more often, but they don't have to pay higher rates because of their age. So we always want to talk about the umbrella. And the next 2 pages after this give you a form letter that we use. We write a letter to the insurance agency saying, we represent this client. We want to make sure you know about all their stuff. Please call me if there's any need to change their coverage. And whenever they call that letter in Clearwater, they call it the Gassman letter, because they say when they get it, it just sends shivers up their spines. And they always call me later and say, the doctor's not getting sued, is he? No, he's not. But where are the gaps? And there usually will be gaps. And spending an hour or 2 hours on this, if you're billing hourly, is a great investment for the doctor. The next page also shows you the other types of insurance coverages that the doctor should have. And then
Alan,
on the next,
let me just interject a quick comment. The point Alan made, I just want to reemphasize about having an appropriate umbrella policy. I would say 90% or 95% of the clients I see, all clients, have an umbrella policy limit that is woefully inadequate for the risks and liability they face, and I don't understand why. It is the most common that I see people with a $1 or $2 million umbrella, no matter how large their net worth and no matter the liability exposures they have. And Alan's point is just so important. To increase an umbrella policy from 1 million to 5 million or 5 million to 10 million is really not a significant cost factor. And especially for physician clients who tend to focus on the malpractice risk to the exclusion of the other risks that Alan has so well, explained on this program, make sure you get one of the first questions to the physician client. What is your umbrella? Is it adequate? And address the points that Alan made.
okay, so page 30 just shows you some of the coverages that you want to make sure that your clients have. We'll go to the next. Now, page 31, I'm not going to spend a lot of time on malpractice insurance, but I'm going to tell you that there are lots of traps for the unwary and lots of opportunities to improve the situation. For example, a lot of physicians don't realize that they could add coverage, they could double their coverage, sometimes for only 10 or 15% more than what they're paying, by putting a separate policy on the medical practice entity. Usually the malpractice policy is to the doctor. The doctor is the insured, and the entity doesn't have a policy, but it's an additional named insured under the policy. Many carriers will give the corporation an additional layer of coverage for very little money, and that can become very important if a doctor leaves the practice and does not buy a tail. Medical malpractice insurance usually is called claims made, which means that the policy only covers situations where the carrier is informed of a malpractice claim during the term of the policy. At the end of the policy, you have to buy a tail to protect the doctor for after the doctor is no longer using the policy. It costs 3.5 to 4 times the annual premium. So you just have to be thoughtful about this. I had a situation just came up this morning where a doctor who is a very dedicated doctor, 65 years old, he's retiring, he gets a free tail from his malpractice carrier, but if he does volunteer work, the tail vanishes. So now, because the carrier has this exception for volunteer work, he's going to have to come up with about $250,000 to satisfy his contractual obligation. Most carriers allow volunteer work, so you just have to be careful. The next slides lay out the question of how much, or the next slide after this, lay out the question of how much malpractice insurance costs and how much you should have. For example, across the top here, Dade County internal medicine physician, that's in Miami, would pay about $16,000 a year for $250,000 coverage, or about $26,000 a year for $1 million coverage. Look at a dermatologist. Dade County, a dermatologist would pay $8,800 a year for $250,000 coverage, $14,000 a year for $1 million coverage. I mean, if this doctor is making $1 million a year, quite typically, he or she will only have $250,000 coverage because they're being told that plaintiff lawyers will not sue them if they only have $250,000 coverage. Well, plaintiff lawyers are typically in the game for 30 to 40% of the settlement or the jury verdict. That's about $100,000 on a $250,000 policy. So my advice is to not test my asset protection plan as much and to have plenty of malpractice insurance. Yes, it does put a bigger target on the doctor. The other thing is, quite candidly, doctors do make mistakes, and when they do, they feel pretty darn guilty about it. It feels better to see the family get $1 million check than a $250,000 check. Adding with a good malpractice insurance agent who specializes in this area will often improve the situation of the doctor and the medical practice. What's next? Okay, we're going to skip the advantages and disadvantages because I think you can read through them and you kind of have a feel for it anyway. Let's go to one more. Now, this is really important for doctors. We can go back one. We'll go to 37, Marty. Here's some practical advice that a lot of doctors have told me is very helpful. Number one, don't take patients who are high risk. 80% of exposure comes from 20% of conditions. If you can avoid taking the patients with these conditions, there's probably another doctor in town who would love to handle them. Number two, have other providers involved so it's not only your malpractice insurance. For example, a lot of Florida primary care doctors have nurse practitioners or physician assistants with $1 million each coverage. So they, quite candidly, don't see patients alone. They involve the other professionals so that if there's a claim, there is plenty of coverage. Even to the point of number three, put the patient in the hospital because the hospital has huge deep pockets, and use as many specialists and get as many doctors involved as possible when it's best for the patient, and it also helps to reduce liability exposure. Number 4, and I think this applies to everyone on this call, anytime you have an encounter with a client, think for 45 seconds, what can go wrong and what can I do to avoid this going wrong? And with physicians, it is usually making sure that you document the advice you're giving in your chart notes, making sure that someone in your office will follow up and not let this patient accidentally slip between the cracks, and making sure that you tell the patient what to do with the medication or the treatment that you are giving them. You will go to the next number 5 here. You will live and die by your chart notes. We see so many situations where doctors come to us and say, I know I told her that, I know I handled it, I know we mentioned it, but I forgot to put it in my chart notes, and I used the wrong name, and I said the left hand when it should have been the right hand, and I didn't notice that the doctor before me mistook that it was the left eye, not the right eye, and I copied and pasted the same description, and all that stuff looks terrible, awful to a jury. Don't ever change your chart notes retroactively unless you've conferred carefully with legal counsel. Number 6, and this goes to all of us too, don't co-manage professional arrangements with sloppy professionals. You know, you get referrals from different doctors. You may have to sit down with them and say, hey, I don't want to work with you anymore because I can't read your chart notes. You're not following up properly, and I'm going to get sued when a patient gets hurt. So and a lot of clients do bring in independent consultants to review all the charting of the medical practice in order to criticize and correct the charting of the doctor or doctors who are the weakest. It's not easy to have that conversation to say, hey, I love having you as a partner, but stop being so darn sloppy. You're going to get us all sued. So you might hire a consultant to come in. And then finally, a lot of medical practices require their patients to sign arbitration agreements, especially OBGYN practices in Florida. For sure, a majority of them require arbitration, and the arbitrators will be doctors. So the runaway jury system and confused juries will not apply. You have to check with the malpractice carrier to see if they allow for that. Many of them really like arbitration, so at least think about that for your highest risk patients. Marty, do I have a minute or two, or is it time to
keep going? No, we can go a couple more minutes.
Okay, page 38. I just want you to make sure you understand what the exemptions are in your state. I don't have any reason to tell you what the Florida exemptions are. You can see on the left-hand side, we protect Homestead Unlimited, IRAs Unlimited, 401ks Unlimited, life insurance Unlimited, annuity contracts Unlimited, but most states do not have that. We even have tenancy by the entireties protection. A lot of states have tenancy by the entireties, but it doesn't protect the assets from the creditors of one spouse or the other. You should have a chart like this. You should go over it with your clients. Most clients and most physicians are visual learners. This documents that you told them what was protected and what was not protected. And then the next slide is where we want you to lay out a chart for your clients showing them how their estate plan will look. You have spouse 1, spouse 1's revocable trust. It's to avoid probate. It shouldn't own a darn thing. We don't put anything in spouse 1's revocable trust. It's going to be the beneficiary of life insurance. It may be the beneficiary of an IRA that'll be a stretch IRA. It may be the beneficiary of life insurance or annuity contracts, but it's a huge mistake for doctors to set up revocable trusts and put any assets in them. And then you have to decide, what am I going to own jointly and what am I going to put in my spouse's trust? Because if I'm a neurosurgeon and my spouse is a soccer coach, my spouse's trust can have assets, especially if there's a $5 million umbrella covering my spouse's driving. And then an irrevocable trust for the children that you might donate $15,000 per year for each child, going to be spent on college and buying them their first house. And then one of Marty's favorite things, the SLAT, a lifetime trust for the spouse. So spouse one puts $1 million into the lifetime bypass trust, which benefits spouse two, provides spouse two and the children with health, education, and maintenance. Creditors can't touch it because spouse one is not a beneficiary. They can't touch it because spouse two is limited to receiving amounts as reasonably needed for health, education, and maintenance. If that trust is in an asset protection jurisdiction, such as Alaska or Nevada, where Peak Trust can help you, then you might be able to have spouse one added to that trust if and when ever needed by spouse one because of circumstances that are at this point unforeseen. Now, the next stage,
we're gonna have to stop because we're kind of near the end, but let me just make a comment. Alan and I are gonna do a program next Friday, same time, same place at 12 noon. You need to separately register for that program. My office will send out an email by Tuesday to give you a chance to register for that if you haven't. The email that you got to register for this program also had the link for that. The next session, we are going to take these concepts that we've started to talk about on slide 39 and talk in a great more detail about using trust and other planning to protect the physician's assets and a lot of the mistakes that Alan and I see and how people handle that. So we're going to wrap up for today. I want to thank Alan for a great presentation, since you certainly led the charge with most of it. I want to thank the American Cancer Society and Peak as our sponsors for today. And thank you for joining us, and do try to come back. We will provide a recording of this program, and the PowerPoint will be posted to schenkmanlaw.com /webinars on our website, so you and any of your colleagues can access it at any time at your convenience. Just give us about a week to get it posted. Thank you, Alan, and thank you, everybody, and we hope to see all of you next Friday at noon as well. Thank you.
thank you, Marty.